whiria te taura, te kaia te korowai tuakiri. Kia rongoa i te mana, kia rongoa i te Māori, kia mā koha, kia mahana, kia wātea, tūraha. Ko te mihi tuatahi ki te atua nāna nei ngā mea katoa. Ko te mihi tuarua ki te hunga mate, haere atu rā. Ko te mihi tuaruturu ki te hunga, ora kua hui mai nei, tēnā koutou, tēnā tātou katoa. Good morning. Today we're going to do a piece on fines enforcement. We have noted that as we move through this year, that there has been a lot of pressures on household expenses and obligations. So we're going to do a piece on fines enforcement and what it means. So, what is a fine? A fine is a monetary penalty imposed on an offender for a breach of the law. A fine is a form of financial punishment generally payable to the government. Its primary legal purpose is to penalise the offender for a prohibited activity. It is to deter or discourage the offender and the public from committing similar offences. Imposing a fine can be less disruptive to the life of an offender than other forms of punishment, such as custodial sentences. Infringement fines allow minor misconduct to be dealt with quickly, with no court hearing costs, none of the inconvenience or public embarrassment involved in a court appearance, and no criminal record for the offender. Now, the types of fines. You can have court-imposed fines. These are given by a judge or a justice of the peace after a person is found guilty of an offence in court, such as drink driving or theft. Infringement fees, turning into fines. An infringement fee, such as a speeding ticket or parking ticket, technically only becomes a fine if it remains unpaid past its due date and is transferred to the court for collection. So, our legal distinctions between an infringement fee and a court fine. An infringement fee is issued by police or local council. Alternatively, a court fine is imposed by a judge or a JP in court. An infringement fee generally does not result in a criminal conviction. A court fine can result in a criminal record. Example, a Category 1 offence. Fixed versus variable. Usually a set fee is based on the offence for the infringement fee. An amount is determined by the court based on sentencing principles under a court fine. There are no initial court costs for an infringement fee until it drops into the collections unit or courts. When it becomes a court fine, usually it includes additional court costs of, as an example, $55. Important difference from other payments. Reparation is unlike a fine, which is a punishment paid to the government. Reparation is compensation paid directly to a victim for damage to property or emotional harm. Civil penalties or civil debts. These are typically used in a commercial law to determine misconduct rather than as a punishment for a criminal act. The enforcement consequences. If a fine is not paid within the standard 28 days, the Ministry of Justice can take enforcement action, which includes deductions from your bank or your income, seizures, seizing and selling your property, including vehicles, to cover your debt. There could be a credit impact. Unpaid fines may appear on your credit report, affecting your ability to get loans or credit. Now, the court process. The court can take money from you if you don't pay a fine within 28 days, or you haven't arranged to pay a fine over time. The court can take money from your wages or your benefit, using an attachment order, or your bank account using a deduction notice. The law requires employers, work and income, and banks to make the deductions. Only the court can stop or change your deduction. The court can clamp your car. Your car can be clamped for unpaid fines. The court can only release it if you pay in full or make an arrangement to pay your fines. The court can seize your car and property. If your property will normally be sold, if you don't make arrangements within 7 days. Money from the sale will be allocated according to paying the costs for the seizure and sale, such as transport, storage and auction costs, to any of the unpaid fines, and to you if you have money left over after paying out all the costs I've stated earlier. Now, the court can stop you from travelling overseas. Now, this is something that not a lot of our people understand or know, but that if you wish to travel and you've got some fines outstanding, it does pay to contact the courts to make sure that you've got it under arrangement and that there is no reasons for them to take any action. If you ever have unpaid fines and try to leave or come into New Zealand, so meaning if you go on holiday and it wasn't picked up and you come back and you've got fines, the police can stop you at the airport. You'll be allowed to pay by credit card over the phone with the registrar. If you don't pay, the police can arrest you, prevent you from travelling, meaning leaving to go on your holiday or go overseas, or confiscate your passport. They will then summons you to appear in court at a later date. If you have a payment arrangement and your payments don't continue while you're away, you may be stopped when you come back in to New Zealand. The court can suspend your driver's licence. The court can suspend your driver's licence if you have an overdue fines from traffic offences. You will be sent a warning letter before this happens. If you do not respond to this warning letter, an order will be made to suspend your licence. This order may be served on you by an officer of the court or by a police officer if you are stopped on the roadside. Once served, the order will be enforced. You will no longer be permitted to drive and you will be required to surrender your licence. If you drive whilst you're suspended, you risk having the vehicle you are driving impounded for 28 days. And of course, you'll go to court for that. So as part of this second part of my presentation, I'd like to talk to you about civil debt. When the court makes a decision about a private disagreement over fine or property, that is what we call a civil debt. The court's decision is known as an order or judgment and tells one party, who's the debtor, and the court's decision is known as an order or judgment and tells one party, who is the debtor, that they must pay the other party, the creditor. Creditors can ask the court to help them collect the debt if the debtor does not pay. This is called civil enforcement. The creditor may have to pay fees. Usually fees can be and are added to the debt. You can, as a civil creditor, you can ask the court to help you collect your civil debt if the debtor does not pay. You can only bring civil enforcement when two conditions are met. A court or tribunal has found in your favour and orders a person or an organisation to pay you a debt or a civil debt. The 48-hour stand-down period has passed since the order was made and the person or the organisation has not paid you on time. So those are the two conditions that need to be met. You must manage and apply for civil enforcement yourself. It is not automatically done for you. Nothing that the courts will do. They will act on their own. They will only ever wait for your instructions. So it's really important that you understand the requirements that you must meet in order for court enforcement to be acted upon. You must select the enforcement action you think are best for your situation, and there's a number of them. And if you visit the Ministry of Justice website, you'd be able to get get a good understanding of what each one means to you or could be for you. You apply to the court to carry out the enforcement actions you have selected. You give the court correct, up-to-date information about the debtor to support the specific enforcement action you are requesting. Now, that is really important. Now, the courts won't look for an address for you. They will not search their database to assist you in finding the debtor. This is all on your requirements. You will have to go and seek all that information yourself. And you must pay the associated fees for each enforcement action you request. Now, again, this most of the time it will be added to the debt. So once the debtor has been notified of your enforcement, of the enforcement, the fees will be added to that debt for you to recoup. Now, how to decide on what enforcement action to apply. And again, this is freely available to you on the Ministry of Justice website. Now, it's important that you go through this step for yourself because it's not an easy process or a simple process. Step 1, you must check the court order. If the court order is over 6 years, then learn about enforcing an order older than 6 years. It's not the same process as if you just had the judgment awarded to you. If it's older than 6 years, you must go and seek some information in regards to it. If you apply to the court for help, the court can assess the debtor's finances on paper. Now that's after you've served and provided information to the court to serve documents for them, to compel them to come to court, to disclose their financial situation and how much they can afford to pay. You can have the hearing, a financial assessment can be heard over the phone. Right, you must check to make sure that your court order is not over 6 years old. There's a different requirement for you in the process of collecting your debt. If you apply to the court to help you locate and have the debtor assessed for their financial situation, the courts will choose how the debt should be paid. This is after they've gone through the financial assessment by the courts, and you will get a copy of all of those things, all of those paperworks, so that you can see how they came to that assessment. You can also apply to have a deductions from their wages or benefit, which is very similar to what I talked to you about for fines enforcement, for fines and reparation and so forth. However, this is where you've got to apply to our courts and get them to file for an attachment order. If the debtor has valuable assets, now this is really an important matter it's not easily understood. If they have valuable assets, you've got to state what they are. Normally, it's known a car would be a valuable asset. And if you want to have a warrant you can apply for a warrant to seize. You can apply for a warrant to seize. You must include a copy of the judgment and you must pay a filing fee. Again, this will be added to the debt. If you know that the debtor owns specific valuables, you can ask the bailiff to seize it. However, you need to provide evidence that the debtor owns that property. The bailiff or the courts will give you instructions on what it is that they require from you for that information. After the application is filed, The bailiff will go to the address you've supplied on the application form and attempt to seize the debtor's property. There is no time frame for this process due to a number of factors, i.e. location of goods to be seized and locating the debtor. Locating the debtor is the biggest issue. But you should receive a letter notifying you of the outcome within 8 weeks. If the bailiff seizes the property, the debtor has 5 working days to pay the debt in full. If they have not paid after 5 working days, their property is sold at public auction. Money for the sale will be used to pay for the cost of having the property seized and sold, i.e. if it's a car, it's towage and auction fees, and then if there's any money left, it will be paid towards you. If the bailiff cannot find the debtor, you will need to file a new address or consider a different enforcement application. So going from step 1 through to all these steps, the courts are pretty much indicating there's no guarantees and that you will be expected to make the decisions as and when required if the first process doesn't work. It's always good to keep in contact with the courts to keep them up to date with what's going on, especially when or if you're aware of the debtor moving on to another location. If the bailiff cannot find the debtor's property, you will be notified, and if this happens and you find out the debtor has other properties, you can apply to reissue the warrant. You will need to pay the fee. Right, now I've touched briefly on civil enforcement seizing property. It wouldn't be easy to choose an enforcement action, especially if you're not sure on the location of the debtor. But the courts are there to assist you in the enforcement process. They aren't there to provide more information like the debtor's address or what their assets are, because they wouldn't have them available. However, they are there to assist you with going through the enforcement process and to check on what kind of enforcement action is suitable for you. It just takes a bit of time before any of this can actually be actioned correctly. A civil debt comes under the order that a tenancy tribunal issues. So if you have a judgment made in your favour from a eviction that you have provided or done to a ex-tenant, you can process that through to civil enforcement. Now, as long as those 2 criteria that I mentioned, which is that you've got an order in your favour and that it has been at least 48 hours after the judgment has been passed. So those 2 are the requirements before you can start on your civil enforcement. It is a requirement for them to be financially assessed before an attachment order is attached. And attachment orders are usually the most common process to adopt. So because it goes either to their income or to their bank account. Well, thank you. That's the conclusion of my kōrero today. Fines enforcement and touching briefly on civil debt enforcement as well. I will come back next week to cover off the civil enforcement process and any other issues that we might come across during the process. However, what I would like to say is a thank you very much for listening to me this far. We have got a few things on the go within community law. South Auckland. We've just ramped up our new Facebook page. Please go and have a look at it and subscribe and click on and engage. If you've got questions, please engage. We've got multiple amounts of legal educations that we are wanting to go out into the community with. So please reach out to us if you feel that there might be a group or a group to supply the education to. We've also got, and next week we're going to have one of our lawyers do our podcast legal education, and that should be interesting. So thank you very much, and I'll sign off for now.